Hi there, Michael Bovee. I'm with Consumer Recovery Network. Thanks for tuning into our YouTube channel, DebtBytes. Today I'm going to talk about a aggressive type of collection, late stage collection you might be dealing with and have questions about because you were sued and a judgment was entered against you, which means the collector or the bank or the collection attorney has extraordinary options available to them that are going to depend on your state laws. What I'm referring to here is wage garnishment and also bank account levies. So every state has a cap of how much your wages can be garnished. Most of the states follow the federal guideline, which allows up to 25% of your wages to be garnished. And then there's state-specific things that allow you some exemptions, right? So if you're a single household or you've got expenses that are special needs situations, things that would make you exempt, even though you could be garnished up to the cap in your state. There's extenuating circumstances that you have to bring up with the court. So if you're watching this video and you have a concern about wage garnishment, or your wages have been garnished and now you're wondering what to do, first thing is to determine how much of your wages are at risk. Again, that's state specific, so you're welcome to post in the comments below what state you live in and what your circumstances are, and I can offer feedback. We respond to all comments on our channel here, each video. So do that, but then you typically understand you have to petition the court or formally contest the garnishment with the court if you think that you have some exemptions that are going to apply to you, whether or not you meet the state cap, or whether any part of your wages can be garnished, or if only a portion can be garnished. And in this situation, I'm sure you would agree that any amount of your wages that you can keep, if not all of them, even just if you can reduce the garnishment, is going to be helpful. When there is a wage garnishment, the debt collectors, while many videos on our YouTube channel here talk about how to settle debt, how to negotiate with creditors, debt collectors of every flavor, including debt collection attorneys, when they've got a garnishment against you, they're about as confident as they're ever going to be in how collectible you are. In other words, as long as that garnishment is allowed to stay, you can test it, and either a full garnishment or a partial garnishment is going to stick, they're guaranteed to get their money plus interest usually, as long as you have that job. So it's just a very difficult scenario to try and negotiate a reduction or a settlement. It's possible. I've done them. You can do them, but it's just not as probable, and any kind of reduction is going to be not as good as if you had tackled the situation sooner than when they got the garnishment. Now, bank levies, that's another state-specific scenario. So like if you live in New York, you have a certain amount of cash in your bank account that is going to be protected from a bank levy, from a judgment creditor trying to force the payment. This is, again, one of those extraordinary options that judgment creditors have, versus living in another state where you don't have any cash exemption. So where there's, going back to the wage garnishment, there's several states that have very advantageous laws as to all of your wages are exempt from garnishment. Those would be places like Pennsylvania, North Carolina, South Carolina, head of household types of garnishment available to people in Texas and Florida. Those are great. Those are the great places to be, and there are good places to be as far as bank levies too, as far as how much is protected. But there's some of us that live in states that we could go to bed with $1,500 in our bank account and wake up and it's all gone. So you want to be aware of that. There's some things that you can do to protect yourself. When you're dealing with judgment creditors and you want to take away, they've already got all that leverage, right? The judgment, the enforceability. You can take away some of that leverage that they feel that they have and then go negotiate and resolve it, which you do want to do, by the way, because they don't go away. They can be renewed. They last for a long time. Even if they're not on their credit report, they can hold you back from accomplishing other financial goals. So until you reach that point and your cash in your bank account is at risk, you can look for alternative ways to bank. Okay, some people use prepaid cards, debit cards, put money on there, pay bills that way. If you're married and have a joint bank account with somebody, something like that, you could take your name off of the account. The reason they can go find your bank account in the first place is they do these sweeps, and they do them, it has to happen inside of a day. And so they have your name and your social security number, and they do these bank sweeps, and that's how they find you. So if your name and social security number are not attached to an account, then they're not going to be able to attach the money in it. So your spouse, not part of the scenario. And then once you resolve the account, you negotiate it, even if it's on payment terms, they're not going to, if you have an agreement in place to repay with them, they're not going to look for those wage garnishments in those cases. By the way, get all that documented so that you can make sure your butt's protected. But once you have a solution in place or the judgment's resolved, you can then add your name back onto the account. Those are some of your options. Those are the things you have to think about, unfortunately, when you are, you've got judgment creditors that have extraordinary means to get you to pay. There are some things that you might be watching this video that may apply to you. These are extra protections. I cover them actually in detail on a post on my website about if you got Social Security, disability, things like that. If the only money in your bank account is deposited from an exempt source, like that, a government source, then those things are protected by themselves. When you mingle that money with things that are not protected, and I don't care if the only thing in there is Social Security benefits, and then you put a $100, like say a birthday check that you got, and you deposit that, you've just mingled that $100, and the bank doesn't know. They're not going to do that research to the extent that they would need to. So they're going to protect your money if it's from an exempt source, but if you've mingled other money in there, I would encourage you to actually just cash that check. Or if you have regular sources of income that come from a non-exempt source, you may even want to just have a different bank account for that and keep it down to nothing or close to nothing, while the bank account that only has your exempt sources deposited in it, that's fine. You also do not want to have too many months worth of those checks, okay? So if your only source of income is exempt sources, you're probably burning through that every month for bills and just household things. But in the event that you do allow that to build up over time, it becomes non-exempt, right? So you want to be careful at how much cash you keep in your bank account, even if it's from an exempt source. See you on the next video.